Contract disputes can be complex and frustrating. But what if you need to cancel a contract entirely? That's where a letter of rescission comes in. This powerful legal tool allows you to formally cancel a contract when certain conditions are met. Let's explore how to use a letter of rescission effectively and protect your rights. A letter of rescission is a formal notice used to cancel a legally binding contract. It's typically employed when a contract has become voidable or invalid due to specific circumstances. This isn't just a way to back out of a deal you don't like anymore. There must be legitimate legal grounds for rescission. So, what are these legal grounds? They include fraud, where one party knowingly provided false information to induce agreement. Misrepresentation, even if unintentional, can also be grounds for rescission. Other valid reasons include duress, where a party was unfairly pressured into signing, mutual mistake about fundamental facts, or a significant breach of contract by the other party. Some contracts, like real estate purchases or insurance policies, may also have a statutory right of rescission within a specific time frame. Now, let's break down the essential components of a well-crafted rescission letter. Start with a clear heading stating letter of rescission and the current date. Include the recipient's name and address. Reference the original contract, specifying its date and relevant details. Clearly state that you are rescinding the contract and provide your legal justification. It's also wise to request written confirmation from the other party. Finally, don't forget to sign the letter and include your contact information. Time is often of the essence when it comes to rescinding a contract. The allowed time frame can vary significantly depending on the type of contract and your jurisdiction. For example, some states allow a 3-day right of rescission for home purchases. Consumer contracts often have cooling-off periods mandated by federal law. Insurance policies typically offer a rescission period of 10 to 30 days. It's crucial to act quickly, as exceeding these time limits may leave you with fewer options for resolving contract disputes. What happens after you successfully rescind a contract? Generally, both parties are returned to their original positions as if the contract never existed. This means any exchanged money or assets must be returned. Neither party is required to fulfill any remaining duties under the contract. However, be aware that in some cases, one party may need to compensate the other if the rescission causes financial harm. It's important to distinguish between rescission and contract termination. While rescission cancels a contract as if it never existed, termination simply ends it moving forward. Rescission requires specific legal grounds and nullifies the entire contract. Termination, on the other hand, may be voluntary and keeps past obligations intact. The process for each can differ significantly, with termination often following a clause in the contract itself. In conclusion, a letter of rescission is a powerful tool for canceling a contract when legal grounds exist. Remember to act quickly, clearly state your reasons, and include all necessary details in your letter. If you're unsure about the best course of action, consulting with a contract attorney can help protect your rights and ensure you're following the correct legal procedures. By understanding the process of rescission, you'll be better equipped to navigate complex contract situations and protect your interests.